Mr. Boyle.
My Lord, may I briefly complete the chronology? I'd reached the date 10th of January 2012 and referred to Gany's extraordinary letter. I won't go on about that. The claim form was issued on the 27th of January 2012, seeking disclosure of information relating to the ZVM Trust and the subtrust. Walker's then came on the record, and on the 9th of February and 16th of February 2012 repeated the position taken in the extraordinary letter that the $2 million had exhausted the trust assets. There was then an affidavit sworn by Khalid on the 2nd of April 2012, which is at volume 5, page 1719. It's important to understand, I won't take you to the affidavit, but it was based, as it states, on information supplied by Asif, and there was in fact a finding by the judge at paragraph 2 of his judgment that Asif controlled Gany. So although the affidavit was by Khalid, the information came from Asif. And there are a number of points about it. It asserted for the first time that there was a lifetime gift by Ma of his business assets. That's at paragraph 16. It asserted that ECL HK had no value and that in any event it wasn't an asset of the trust. It asserted that Khalid had made inquiries about the position prior to his appointment as a director of Gany in April 2000 and that there were no records. Turned out that there were records and they were later produced, or at least some of them were. Fourthly, it said, I have discovered that the only asset of the trust was the settled sum, that's the $100. Fifthly, it specifically denied the existence of any documents relating to the ZVM Trust other than the ones already supplied to Zorin, but the 1998 appointment was not mentioned and had not been disclosed. Sixthly, the affidavit now retracted the assertion that the $2 million payments came out of the trust, an assertion which had been in Gany's letter as recently as the 10th of January and thereafter repeated twice by its solicitors. And seventhly, the affidavit recounted the waiver letter and explained that Khalid understood, as is obviously stated in the letter, that the money came from the ZVM Trust, but he now says that he'd been told by the Asif that the money came from the MA Foundation. And the misinformation supplied to Zorin at the Dubai meeting was described by him as confusion on the part of Zorin. That's paragraph 34. So on the 4th of April, and I don't think this was mentioned, Mr. Justice Bannister ordered disclosure by Gany in respect of the trust and the companies held by the trust. That's at volume 1, page 23. And on the 1st of May, the ordered account was provided in the form of an affidavit by Khalid exhibiting the accounts. They were at 51729, and that's the affidavit, and the account itself is at 61299. And Khalid swore in that account that the assets of the trust consisted only of $100. The respondents then filed a notice of admission on the 27th of July 2012, which alleged that ECLHK was an asset of the trust and that it had substantial value. And Gany filed points of defence on the 21st of February 2013. And it's important to understand that as originally framed, the defence alleged that the ECLHK shares had been transferred to Gany as a bare trustee for Asif, that's at 142. And the 1998 appointment, I'll come back to this point when we deal with ground 2, the 1998 appointment was explained on the footing that Gany wanted to remove any doubts as to the trusts on which the $100 was held, and to give effect to Ma's wishes with regard to that $100. It was only by amendments made in March 2014 that it was finally admitted that the ECLHK shares were an asset of the ZVM Trust prior to Ma's death, and the relevant allegation, which was in paragraph 10.11, was changed to a plea that the intention of the 1998 appointment was to give effect to a wish to remove doubt as to the trusts on which the ECLHK shares and the $100 were held. Asif had been joined as a party to the proceedings on the 8th of July 2013, and on the 11th of November he pleaded that all of the assets of the trust had been distributed to him under the 1998 appointment. He didn't say what assets had been distributed to him, and it was only in answer to a request for further information that he first admitted that the assets transferred comprised the ECL HK shares. That was on the 20th of December 2013. My Lords, the Court of Appeal had this lamentable history well in mind when examining the key issues in the case, and in particular in examining the effect of the evidence regarding the three companies and the approach which they should take to the burden of proof and the applicable presumptions. Now, may I go to the companies issue, and may I begin by summarising what our position is on the first issue. We submit that the Court of Appeal was right to reach the conclusion that the account furnished by Gany should include Schweitzer Holdings, Sedilla and ECL BVI for the following four principal reasons. One, the first issue for the trial judge to determine was whether there was a gratuitous vesting or transfer of the shares in the three companies by Marr to Gany in 1994. On that issue, we say that the trial judge made a fundamental error in paragraph 65, last sentence of his judgment, in holding that there was no evidence that Marr made a gratuitous transfer of those shares to Gany. We submit that that was the clear effect of both Asif's written and his oral evidence. My Lords, that is at page 189 of volume 1.
I'm sorry, page?
Page 189 of volume 1. I'm sorry if I'm slightly inaudible at times. The critical sentence which we criticise and which the Court of Appeal criticised is the last sentence of paragraph 65. He there says, in this case, there is no evidence that any property other than the ECL HK shares was the subject of a gratuitous transfer to any of SFL, MISA or Gany, while each was a trustee of the trust. And that is simply wrong, and the Court of Appeal rightly found that that was wrong at page 250, paragraph 86. They said the overwhelming evidence that was before the judge indicated that in addition to the ECL HK shares, Gany also held shares in ECL BVI, Sedilla Investments and Schweitzer Holdings. Accordingly, the judge made an incorrect finding of fact when he stated there was no evidence that any property other than the ECL HK shares was the subject of a gratuitous transfer. There was evidence that Gany held the shares in these companies, and insofar as Gany has led no evidence to rebut the presumption, it must be regarded as holding the shares on trust for the ZVM Trust. Now, it's true there's reference in that paragraph to a presumption, but the first point is as to the evidence that was before the judge on the way in which these companies were dealt with. And if I can just, if this has actually nothing to do with the operation of any presumption, it's a simple question of fact. And we say the judge misapprehended the evidence that was before him. And the very short point, which I will come to in a moment when we look at Asif's written evidence, is that what he said was that the gift of assets to him had been carried out by vesting companies in Gany and then Gany being given to him. That was his explanation. So the way in Asif's evidence this was explained was that in order to carry out the lifetime gift, assets were placed in Gany and Gany was then given to Asif. That was the mechanism. And we've pointed this out in our written case, but it wasn't a matter that my learned friend really addressed at all. But it is the central point on which we rely for saying that the judge simply got this wrong. I'll come back, if I may, to the evidence in more detail. So just carrying on with our 4 points, the second point is that the second issue for determination was, with what intention did Marr vest the shares in Schweitzer Holdings, Sedilla and ECL BVI in Gany in 1994? Now, I put the point that way without reference to any presumption, because if the court has evidence from which it can deduce the relevant intention, then there's no need for a presumption. The presumption only comes into play in this area of the law to fill an evidential gap as to what the transferor's intention may have been. Now, that second question was never considered by the trial judge because, as I've shown you, he answered the first question in the negative. So you cannot read in the judgment a finding that the intention was that Marr should retain beneficial ownership of the assets which were transferred, because the judge never addressed his mind to the question because he fell, as it were, at the first fence and never got to the second one.
There is a sentence in the judgment, no doubt you'll come to it, when the judge says something like, I think Marr intended to retain beneficial ownership until
Yes, he
died.
does.
But no doubt you'll come to
that.
it.
I will come to that. That's paragraph 66, which is a difficult paragraph, as I'll attempt to explain. Thirdly, we submit that in the absence of direct evidence as to Marr's intention in vesting the shares in Gany, the court is required to draw inferences from the known facts. And it's in this area that presumptions potentially come into play, and this was the approach to the case which was presented to the Court of Appeal and which explains, we submit, the way in which the Court of Appeal approached the case. Now, what we say is that the available evidence inferentially established that Marr's intention was to vest the shares in Gany to hold on the terms of the ZVM Trust. And there are a number of points that we rely on as showing that that's the case. First of all, Gany had only recently been appointed as trustee of the ZVM Trust in a deed which Marr himself executed. That was on the 15th of November 1993. Secondly, Marr personally instructed the transfer of the ECL HK shares to be held on the trusts of the ZVM Trust on the 15th of February 1994. That's in volume 8 at page 2881. And if you look at that page, you will see that the instruction is to the previous trustee and to the nominee. So it's from Marley, and it's to the nominee, and it's signed by Marr himself. Please,
could you repeat the page?
It's page 2881 of volume 8.
Thank you.
And he says, please be advised that pursuant to a deed of removal and appointment dated the 15th November, that's the one I just mentioned, Gany Holdings has been appointed the new trustee of the ZVM Trust in our place, and you are hereby instructed to forthwith transfer the shares to Gany Holdings as trustee of the ZVM Trust and execute the enclosed instrument of transfer, deliver same to Gany Holdings. Thereafter, the declaration of trust dated the 19th of March will be returned.
And that's Marr's signature, right?
That's Marr's signature. And this is the 15th of February 1994. So what he's done is appointed Gany to be the trustee, and in February he instructs the old trustee to transfer the assets to the new trustee. And the instrument of transfer itself is on the next page at 2882, and that's also signed by Marr. And that's dated the 16th of March, 1994. Now, Ma obviously, 2 days later, on the 18th of March, the share in ECL BVI is allotted to Gany. That's at 2867. You see the register of members and the share ledger, and that shows that Gany was entered as a member of ECL BVI on the 18th of March 1994, and what it was allotted was one ordinary share of $1. So it's obvious that is, and as the chronology shows, that this was done by Ma. It was formed by Ma. He was the director of the company, and only 2 days after putting the ECL HK shares into the trust, or transferring them into the trust, this share is allotted to Gany. No distinction can possibly be drawn between an allotment of shares and a transfer. It's obvious that the substance of the transaction is that this is being put into the trust by him.
We don't know if anyone was holding shares prior to that. I noticed that this is share certificate number 1.
Yes. The intention, obviously, was to, from this point, to activate what was up to that point merely a dormant company, and to clear up the ownership and put this company into the ownership of the trustee. And the obvious question is, why? Why did he do that? It's obvious from this evidence that Ma was, in fact, orchestrating these events. That is an inference that the court can properly draw. And what he was deciding to do was that this company should be held as a trust asset. He must have been. There's no other plausible explanation, unless you accept Asif's evidence given at the trial that the purpose of putting this company into Gany was to orchestrate something different, namely a gift, a beneficial gift to Asif of that asset. But that's the case which we say the judge rejected in paragraph 66 of the judgment. So the fourth point is that the Asif's witness statement, and indeed his oral evidence, we say, showed that the other companies, which are called Schweitzer Holdings and Sedilla, were transferred to Gany in 1994. I'll come back to why I say that. Now, Ma obviously knew about the ZVM Trust, which he had personally created, and to which he had appointed Gany only a few weeks before. And so we say the natural inference to draw was that investing other assets in Gany, he intended them to be held on the trusts of the ZVM Trust. The only alternative explanation for the vesting of those shares in Gany, which Gany put forward on the basis of Asif's evidence, was that the purpose of this was to carry into effect a beneficial gift of the shares to Asif. But that explanation, we say, was rejected by the learned judge. Seventhly, the case that Ma's intention was that the assets should be held by Gany on a resulting trust for himself simply makes no sense, and was not the case that was advanced by Gany at the trial. It was inconsistent with Asif's evidence of there having been a lifetime gift of all his business assets to himself. Eighthly, we submit the court can take account of what I've described as the lamentable story of the way in which the respondents have been misled about the assets of the trust ever since Ma's death. And ninthly, we rely on the trustee memorandum, which includes reference, says that the assets, says that Ma put assets into the trust, and the list of companies produced in association with that memorandum refers to 2 of the 3 companies. So we say it follows that the correct inference to draw from the known facts was that Marr did intend Gany to hold the shares on the trusts of the ZVM Trust, and that is an application of the reasoning in Re Curtis to the facts and evidence in this case, and that the Court of Appeal was entirely correct to say that that is the right way in which to understand Re Curtis, and that that is a correct application of it to the facts of this case.
You're putting the Curtis case there, are you, as saying basically that you look at the inherently probable inferences, and in the absence of any hard evidence to displace them, that's what you accept. Is that the proposition that you are, for the moment, deducing from Curtis?
Yes, it speaks of a presumption, but in this area of the law,
An inference would do the same job.
it is the difference. I've struggled to find, if I can put it this way, a difference between a presumption and an inference. If one looks at the authorities on the presumption of advancement and the presumption of resulting trust, they all say that actually it's a question of fact, and if you have direct evidence as to what the intention of the transferor was, there's no role for the presumptions to play.
Well, I think the difference may be that a presumption is a legal rule which, given the particular category of facts, you have to follow.
Yes.
Whereas an inference may normally be the right thing to assume, but in some circumstances that assumption would not be your starting point. It's simply a question of weighing the probabilities which differ from one case to another.
But
that is, I think, a difference.
Yeah,
In Van der Velde, it was described as a common sense deduction
exactly
as to what the intent had been.
Yes, and in Pettit and Pettit, Lord Diplock, and we quote this in our case. It might
Well, I
be.
mean, that is an evidential presumption. It's not a legal one.
Yes, well, I think that's right. And as I understand the law in this area, it's a presumption of law as such is something which, as it were, certain facts produce as a matter of law a result.
Yes.
But no one has ever said that any of these
Presumption
presumptions are like that.
Yeah.
That's not the law of these type of presumptions. The passage I'm just looking for is thank you.
Well, we can find it.
Yes, it's at the top of page 3382, paragraph 120 of our case, and we've quoted there from Baroness Hale in Stack and Dowden, and it says the presumption of resulting trust is not a rule of law. That I think is my key point. It's not a rule of law. According to Lord Diplock in Pettit, equitable presumptions of intention, which is what we're talking about here, are no more than a consensus of judicial opinion disclosed by reported cases as to the most likely inference of fact to be drawn in the absence of evidence to the contrary. Equity being concerned with commercial realities, presumed against gifts and other windfalls such as survivorship, but even equity was prepared to presume a gift where the recipient was the provider's wife and child. So that's the way these presumptions all work. It's not about a presumption of law, i.e. if you prove certain facts, this result follows. It's about trying to arrive at the answer to the question I formulated, with what intention was the gratuitous transfer of assets made by the transferor. And if you can deduce from all of the evidence what that intention was, then you don't need any presumption. But if you can't, then you've got to work out by way of inference from the known facts and the inherent probabilities of the case what the intention was.
Would you apply that even to the presumption of advancement?
Yes, it applies to the presumption of advancement and it applies to the presumption of resulting trust as well.
Right.
They're not presumptions of law, they're presumptions of fact.
I wonder whether the presumption of advancement would still exist if it were really to be viewed simply as a presumption of fact, because the social conditions in which people give money to their wives are rather different now.
Yeah, well, that was the very point that Lord Diplock made in Pettit, and he says that these so-called presumptions or rules of so-called law were made in very different social conditions from those which now prevail.
Well, under very different conditions in terms of the availability of evidence of intention.
Yes, yes. So on our side, we don't really see why it really much matters whether you call it a presumption or an inference. The real thing you're trying to do is to work out from all the evidence that you have what was the relevant intention. There must have been an intention, and the only question is, what was it? And where you have someone, as we say, is clearly established on the evidence, gratuitously vesting shares in 3 companies in a company which is just appointed as the trustee of the trust, and the only explanation advanced by the person who was actually involved in those events, namely that that was all a gift to him, has been rejected, well, what are you left with? You're not left with a situation in which you say, I can't answer the question, we've got to answer the question, and you're not left in the situation where you have to assume that because there's no other evidence, he intended to remain the beneficial owner himself. Of course, the trust we're talking about, we haven't been to the trust instrument in detail, but it's absolutely standard, a discretionary trust for a family, and includes as its beneficiaries Ma himself and his children. And so the notion that somehow it would be an odd thing for him to do, to put assets into a trust of that nature, which already held ECLHK, and to add to that for the benefit of himself and his family, is not a far-fetched idea. And that indeed was part of the reasoning, as was pointed out, in Re Curtis, because Re Curtis, that was the way the argument was presented. It was pointed out this morning that this was a family trust, and the likelihood was that in putting these assets into it, he intended to make them available for his family under the trust. It's a similar situation.
I suppose you would attach significance to the letter of wishes in that regard.
The letter of wishes, yes. The letter of wishes, it cuts both ways. I mean, it isn't really a letter of wishes at all. It doesn't refer to the trust. It just says, I've allocated whatever I think is right. Now, if he had already allocated or was intending to allocate assets to the trust, then it's explained on that basis.
Its meaning depends on the answer to this case.
Exactly. It doesn't prove. It proves both cases or disproves both cases. So the error of law
about his personality. And he says, I hereby declare that I've given, already allocated whatever I wanted to give to my family members. So if the answer is 0, or effectively 0, then
yes.
So it's a rather sardonic sort of person that we're...
It's like a roundabout way of saying it.
Yes, he might have. If he really meant it, he could have said, I don't want my family to have anything. But he didn't actually say that. He said something which is really rather different. I've already allocated what I think they should have.
It's a sort of statement of an intention to ski, to spend the kids' inheritance.
Yes. Now, can we come to the evidence? What was the evidence? It consisted of 4 things. The written evidence of Asif, which was a 35-page witness statement, which is dated the 17th of April. Relevant parts of his cross-examination, which were 2734 et sec. Some corroborative testimony from other witnesses designed to support his case of a gift of all the assets, which is summarised at paragraph 85 of our written case, and a very small handful of miscellaneous documents, which represented what must be a small fraction of the totality of the documents which came into existence by way of implementing the transactions spoken of by Asif in his witness evidence. Now, on the question of the first of my 2 questions, the gratuitous vesting of shares in 1994, we say if you look at Asif's evidence, which I think I do need to invite you to do in volume 5, at page 2004, relevant paragraphs are 54, 57, 60, 61, 71, 85, and 87. Before I go to those paragraphs...
You're going to take us to those, are you?
So sorry.
You're going to take us to those?
Yes, I am. Yes. May I summarise what I say they show? One, in discussions in 1993 and 4, Asif persuaded Ma not to give all his business assets, apart from Pakistan and Malaysian businesses, to charity, but instead to give them all to Asif. 2, the gift was carried into effect by vesting all of the assets in Gany and then giving Gany to Asif. 3, the result was that Asif owned the assets by owning Gany, the only exception being ECLHK, which had been in the ZVM Trust from the beginning, and that 4, the gift included ECL, BVI, Schweizer Holding, and Cedillo. Now, if we can just quickly look at the paragraphs that I mentioned. Paragraph 54, he says, he agreed to give me the businesses, and he says if he gave the businesses to me, I promised I would run the foundation and his other charitable organisations after his death, which indeed I've done. On this understanding, he agreed to give me all his businesses, save for the Malaysian business, which was used to help finance the MA Foundation. So the Malaysian business was not alleged to be part of the gift, and if you look back at 47, nor was the Pakistan business. But then 57 is a crucial paragraph. The arrangements for the transfer of the UK and Hong Kong business assets were completed in around 1994 and 1995. The mechanism we used to transfer these assets to me was to place them all in the name of Gany and then to give me control of Gany, both at shareholder and board level. My father therefore transferred the shares in ECLHK to Gany on the 16th of March and made me a director. Prior to this, he was the only director sitting on the board. In December 1994, the one registered share was converted into a bearer share, which I was already in possession of. So that's the evidence that I mentioned about the way, the mechanism for the gift. And then 58 says, although in 1994, I can't remember the precise date, my father gave me bearer shares in MISO and some other companies. In addition, a share in ECL BVI was allotted to Gany. So that's consistent with what's said in 57. Gany, he says, is being put into the trust as part of the gift of businesses to him. And then if we look at 60, he denies that the intention was to put the assets into the trust so that they will be held on trust. And then at 71, he says he had given Gany to me. Gany held shares for itself, as well as in its capacity as trustee of the ZVM Trust. For itself, it held the shares in Cedillo, a BVI company, and ECL BVI. So what he's saying there is the explanation for the fact that Gany did hold these companies. That's quite clear. He's not saying that, he's accepting that they were held by Gany. And indeed, just to complete that, at 85 on page 2024, given the way my father structured his assets, he had very little in his own name. As I've said, he had given all his assets to the foundation jersey. The companies I had were ECL, BVI, Gany, Schweizer Holdings, Cedillo, BVI, and then some other companies which are mentioned. And then just to complete at 87, notwithstanding that my father died intestate with few assets, there were several matters to attend to relating to his affairs. My father needed to be removed as a director, etc., namely Gany and its subsidiaries, being ECL, BVI, Cedillo Investments, and Schweizer Holdings SA. And then and appoint new directors to these companies. Furthermore, my father was still listed as the legal owner of the shares in ECL Hong Kong, although it previously gifted them to me beneficially. So, when you put all of that together, what is he saying? Going back to 57, he's saying these are arrangements which were made in 1994 and 1995. And although no written documentation has been produced at all about how this all actually was implemented, on this evidence, it's quite clear that the companies were gratuitously vested in Gany, and therefore the judge was wrong. He misapprehended this point in the sentence that I showed you in paragraph 65, because the absolutely clear written evidence of Asif, from which he did not depart in cross-examination, was to the effect that these companies were indeed vested in Gany. It's obvious on this evidence that there was no suggestion that that was a vesting for consideration. It must have been gratuitous. And the evidence of Asif was that this all took place in 1994 and 1995, pursuant to an intention to gift those assets to himself. Now, unless, therefore, the judge held, as he did not, that he accepted Asif's evidence on that point, what you're left with is a case in which the three companies were indeed gratuitously vested in Gany, but that the only explanation advanced at the trial, by way of explanation for that fact, was rejected, and therefore the question is, what inference do you draw? And we say that the only possible inference that you can draw from those facts is that Ma did intend that those assets, as the Court of Appeal plainly held, should be held by Gany as trustee, because that was the capacity that it had. Now, mention was made of the accounts of Gany. The accounts of Gany were never produced.
When you say never produced, never disclosed to anyone, or never made up at all?
Oh, we don't even know whether Gany had accounts.
Right.
I mean, a lot of assertions have been made about fact, which, if we had Gany's accounts, would become clear.
I suppose if Gany was only a trustee, an inference from then the non-production of the accounts that they'd never been drawn up wouldn't be as surprising as it would be if Gany had beneficially owned these three companies.
Sorry, I was just distracted by clearing up the mess I've made by spilling my
You say they've never been produced, and that leaves open the question were they produced and were they created and not produced, or were they simply never even created? And if they were never, it wouldn't be so surprising that they were not created if Gany's assets were all held by Gany as trustee.
Yes, I follow. That must be right. I mean, the suggestion was that Gany had, as it were, some independent commercial activity, but that's never been established by any contemporaneous documentary evidence or accounts. And if it was engaged in commercial activity, then accounts would have been prepared. As we've seen, of course, the accounts which were prepared for its subsidiary ECLHK, accounts were prepared. But no accounts were disclosed to us, and they would, obviously, had they existed, they would have been relevant disclosable documents. And therefore the inference from their non-production must be that they don't exist, with the inference that your Lordship mentioned. And, I mean, we've never been supplied. There must have been documentary evidence of the vesting of these companies in Gany as trustee. There must have been. These things you don't become a subsidiary of Gany without some documentation coming to an existence. It was never produced. No disclosure of that sort was made. And this is why, if I may, we think that it was a somewhat unjust result that we should have been defeated at the trial by an application of the burden of proof. All of the information which is relevant to the matters of inquiry was in the possession of the appellants. We had no information, and as I've shown, we were being denied information repeatedly. And so we came to court on the basis of such disclosure had been made and the witness evidence that was placed before the court. But when one examines that evidence, it simply doesn't establish that Ma retained beneficial ownership of the assets. The case being advanced was the opposite of that. And the only other two explanations for the transactions which must have happened are one, that our case, which is that Ma intended them to be held by Gany as trustee, and the other, the rejected case, that there was in fact a gift of these assets to Asif. That's the end of the case on that point. So
coming now to the judge's observation that
yes,
Ma wanted to retain beneficial ownership.
if I can just paragraph 66 is a somewhat difficult paragraph. First of all, may I say that in paragraph 27 of my learned friend's case, it suggested that this is a finding that the three companies were in the beneficial ownership of Ma. Well, we don't accept that that is a possible reading of this paragraph. He doesn't mention the three companies in the paragraph, and he had overlooked the evidence about them and the submissions made by the respondents in closing and hadn't appreciated that they fell into a different category. Actually, the reasoning is difficult to follow. As I've pointed out, Asif's evidence was not that the gift included the Malaysian business and the Pakistan business. So he never claimed those were the subject of the gift. But paragraph 66 says that Asif accepted that all that was conferred on him in relation to the Malaysian and Pakistan businesses was control. And then he goes on, I think that Ma retained beneficial ownership or ultimate beneficial ownership of his businesses down to the date of his death. Had he made a gift of them to Asif in 1994, the proceeds of sale of the Malaysian joint venture stake would have been paid to Asif and not to the Ma Foundation or the Rangoonwala Foundation. Now that is a problematic sentence when you understand that it was never asserted that the Malaysian business was part of a gift. I should have mentioned that yes, I didn't read the sentence a little bit earlier. In cross-examination, he accepted that all that was conferred on him at the time when Ma retired was control of the Malaysian and Pakistan stakes, and he accepted that he never became beneficial owner of the others. We actually haven't been able to find that reference in the evidence. But the point is, when he says the fact that the fact that Ma retained beneficial ownership of the Malaysian stake makes it highly likely he retained beneficial ownership of his other business assets. That is, in fact, a non sequitur once you understand that it was never Asif's evidence in the first place that Ma retained beneficial ownership, that Ma gave the Malaysian stake to Asif. And then he says, and conversely, highly unlikely he had transferred any of them to any of the successive trustees of the trust. Now, the problem with that is that it's the same error that the learned judge made in the last sentence of paragraph 65. What he's not done is to advert to Asif's written evidence about the three companies and indeed the mechanism of gift of the three companies of which Asif spoke. because had he done so, he wouldn't have been able to express himself in the way in which he did in the penultimate sentence of paragraph 66. So, my lords, bearing in mind the time, I think I have sufficiently explained the basis on which we support the Court of Appeal's judgment. The basis of the reasoning we submit is entirely correct, and indeed based on a correct understanding of what was decided in Re Curtis. And if one looks at the relevant part of the judgment, the point of law that they were concerned with was whether the burden of proof lay on us, and that was at page 219, the burden of proof, findings of law, the burden of proof was on the claimant to establish the assets held by Gany were held on the trusts. And they said that that was wrong as a matter of law. And we submit they were right to conclude that that was wrong as a matter of law. And the burden of proof point begins at paragraph 79, and they correctly summarise at paragraph 80 what Re Curtis decided. If a settlor subsequently transfers to or vests further monies, a presumption arises, and it does, as long as one understands what one means by a presumption in this area of the law. So then they refer to the evidence. In these circumstances, the principles of Re Curtis are applicable in the present case. So they then referred to the transfer of the allotment of the BVI shares to Gany at paragraph 82. And it's true that you may say that some of the other facts mentioned there are not germane to the main point, but they end up by saying there must be a presumption the share was held as an asset of the trust. And we submit that's correct, that there must be, if you can't explain it in any other way, and you can't. Then Cedilla is dealt with, and then the onus of proof is dealt with. So we do submit, therefore, that the Court of Appeal has reached entirely acceptable conclusions. They were certainly entitled to interfere with the findings made by the learned judge on this issue because, as they said, the judge made a big mistake in not recognising that these three companies had been vested in Gany in the first place on a gratuitous basis. And that really undermines the judge's entire reasoning on this point and enabled the Court of Appeal to go on to consider what they felt was the right inference to draw in all the circumstances from the facts. May I go on to the second issue, which is the 1998 appointment? We submit that the Court of Appeal was fully justified in reaching the conclusion that the 1998 appointment should be set aside on the ground of misconception for the following 6 reasons. 1, the evidence before the trial judge clearly established that at the date of the 1998 appointment, Mr. Salim and Banu Rangoonwala thought that the ZVM Trust held no significant assets. That was Mr. Salim's clear evidence. And on the basis that, as he thought, Ma had previously given away all his business assets to Asif. That's paragraphs 14 and 15 of his witness statement. That's in volume 5 at 2076. Banu Rangoonwala didn't mention the appointment at all. She was present at the board meeting at which the resolution was passed, but didn't give any oral evidence about it. But she said the same thing about the gift. That's paragraph 15 of her affidavit. Asif gave no evidence which put that evidence in doubt, or which suggested that he discussed the value of the assets with his co-directors at the relevant meeting, or that they had any different understanding at that meeting from that described by Mr. Salim. 2. In March 2014, having previously asserted on oath and in 3 different versions of its defence, verified by a statement of truth, that the assets of the ZVM Trust never consisted more than $100, Gany belatedly accepted that ECLHK had at all times been an asset of the Trust. It's clear that on the evidence as found by the Court of Appeal, ECLHK had significant value. That was clear from the materials which were before the judge and which were discussed at the trial. It took the form of the audited accounts of ECLHK for the years to the 31st of March 1998 and 1999. That's in volume 6, 2267 to 2288. And in fact, Asif's counsel, my learned friend Ms. Provisa, put the figure from those accounts in her opening skeleton, albeit getting it slightly wrong, and said that it was Hong Kong dollars 3.5 million. That's at 1378. The actual figure was 2.828, and that was equivalent to about $360,000. And our position was that the mere fact that ECLHK was now accepted to be an asset of the Trust showed that the issue whether the Trust owned assets of substantial value had now been conceded. That was in paragraph 48 of our opening submissions at 1/349. 3, the point of fact on which the Court of Appeal disagreed with the trial judge concerned the value of the ECLHK shares. That was a point which simply depended on assessing what the accounts showed to have been the value of the assets at the relevant date. It was not a point which turned in any way on the oral evidence of any relevant witness, or the judge's assessment of that evidence, or the demeanour of any witness. The Court of Appeal simply relied on what the accounts showed. In any event, we say that the judge was in error when he said, as he did at paragraph 73, that no evidence had been adduced to show that the ECLHK shares amounted to anything substantial in 1998. That's at 1191. That's wrong, because the accounts were in evidence. The value attributed to the shares, or to the assets of the company, was referred to at the trial, and so there was evidence before the learned judge that it had substantial value. Of course, if the 3 companies were also assets of the ZVM Trust, then the position is a fortiori, and there was an even greater misconception on the part of Banu and Mr. Salim. 4, because ECLHK had significant value, Banu Rangoonwala and Mr. Salim were clearly under a misconception as to the extent of the trust assets at the time of the 1998 appointment. Mr. Salim's evidence was that the appointment was made on the basis that the trust had no significant assets, a piece of evidence which was given without even mentioning that the trust owned the shares of ECL HK. I'll come back to that in a moment. 5, it follows that in making the 1998 appointment, Gany committed a clear breach of trust. Before exercising the power to appoint the entire trust fund to ASIF, Gany's duty was to understand the nature, extent and value of the assets which it was proposing to appoint. And it's manifest on the evidence that this didn't happen. The breach of trust consisted of a failure to give adequate deliberation to the question for decision. And that the case is in fact one of seriously inadequate deliberation. Gany thought that it was merely carrying out a tidying up exercise rather than making a substantive appointment of significant and valuable assets. That is actually a difference between chalk and cheese rather than a difference between a small amount of cheese and a large amount of cheese. The substance was that the directors of Gany didn't think, when they did what they did, that they were doing anything of significance other than tidying up this trust. 6, that breach of trust renders the decision voidable, and it should be avoided, and the Court of Appeal was correct so to hold. And given the nature of the breach, we submit it's sufficient to establish that the directors of Gany might have behaved differently had they correctly ascertained the value of the trust assets. And the question whether they might have behaved differently has to be dealt with objectively by reference to the standard of what a reasonable trustee might have done in the circumstances.
The question is whether they would have attached importance to it and taken it into account, even if they might have reached the same conclusion in theory.
Yes.
Is that right?
Well, the question is, the question I'm on is, by what standard do you judge the actions of the trustees in relation to what they might have done had they considered that?
This is a point about materiality, isn't it?
Yes.
So, I mean, are you submitting that the question is not what would they have done if they had known, but would they have thought it through in a different way if they had known? And possibly, but not necessarily, reached the same conclusion, or different one. What is the test?
Well, the first question is, did they give adequate deliberation, and was that a breach of trust?
Yes.
If it's established that they didn't give adequate deliberation to the question, then the question arises, well, did that make a difference to what happened?
Yes.
And in our respectful submission, the answer to that question on our facts can only be, yes, it did, because they were, as I've submitted, they were never really looking at a question, what shall we do by way of appointing significant and substantial
They never had
asset?
to apply their minds to the question who they should appoint to, because they didn't think there was anything to appoint.
Exactly. That's the point. That's the chalk and cheese point. So on our facts, it's really quite straightforward once you understand that the basis on which the decision was taken was an understanding that there were no significant assets and this was merely a tidying up exercise.
I suppose if one attributes to ASIF a bona fide but mistaken assumption that it was just a tidying up exercise, there's no inequity in setting aside the appointment because he didn't think he was getting anything from it anyway.
That's true, although I would question whether...
Well, you may question the if, but the analysis you're making is that this was a decision of Gany,
yes,
in which all its directors, so far as the evidence goes, appear to have been proceeding on the same assumption.
Well, our position is that the relevant evidence is that of the two directors who were asked by ASIF to pass the resolution. That is to say, Mr. Salim and Banu Rangoonwala. We never advanced a case that ASIF himself was under a misconception, but what the evidence showed that he came to the meeting and invited the other two directors to sign the resolution, and they did. After some discussion. In fact, it is quite important. I'm going to show that the evidence on this is really quite limited. And really, in the end, it only turns on 2 paragraphs in Mr. Salim's witness statement. But before I do that, may I invite your attention to how this point arose on the pleadings? What happened, I've shown your lordships already that the Khalid affidavit of the 2nd of April said that the only asset of the trust was $100, and the account said the same thing. And when the power of appointment was relied on by Gany, our answer was to say Gany understood that the assets only consisted of $100 because that's what you've said. And yet the appointment, therefore the appointment conveyed significant assets, there was an obvious breach of trust. That was the pleaded case that we put forward. The Gany's position was Gany's position originally was that the explanation for the power of appointment was an intention to clear up the basis on which the $100 was held. If I can invite you to take, there's a bundle called Respondent's Additional Documents, and the reason we've put this in is that it contains a coloured version of the re-amended points of defence. And at page 4636, I hope that's...
Well, my supplementary bundle starts at 1. Does it have 4,000 pages in it?
It's not a supplementary bundle, it's the Respondent's Additional Documents.
It's Respondent's Additional Documents page, and it's in the electronic bundle, it should be at page 4636.
Yes, I'm in the wrong document. Yep.
If you ignore the Mauve amendments, which were made in March 1994, what this said was, at the date of Ma's death, the defendant held no assets as trustee of the ZVM trust other than the original settled sum of $100, if it was paid. In order to remove any doubt as to the trusts on which it held those assets and to give effect to what had been Ma's wishes concerning these assets, at a board meeting, etc., the defendant decided to exercise its discretionary dispositive powers under the trust so as to appoint the entirety of the trust fund of the ZVM trust to ASIF. And the basis on which it was said that ECL was not an asset of the trust was pleaded in paragraph 10.18 at page 4638. And it was there said, in the deleted words, which are deleted in mauve in this copy, during discussions that Ma had with ASIF and Khalid, both prior to and after 16th March 1994, Ma informed ASIF that he had decided that the ECL share should be transferred to the defendant to hold as nominee for ASIF. So the way the case, and that case, the case that the trust assets only consisted of $100, the case that ECL HK was not an asset of the trust and the case that ECL-HK had been, was held as nominee for ASIF. That was repeated 3 times. This document was amended 3 times, and each time that allegation was made. It was only when the documents that we looked at showing Ma signing that he wanted ECL-HK to be transferred into the trust that that case changed. So the way it was changed appears from paragraph 10.11 on 4636, that the explanation for the appointment was changed from an explanation about clearing up what to do with $100 to an explanation about giving effect to Ma's wishes concerning the ECL shares. So, where's our reply? Just to show the way we pleaded the case, at page 60. Page 74 of Bundle 1, you'll find our case, our pleaded case. If the December 1998 appointment was a genuine document purporting to exercise the power, the claimants aver such purported exercise was flawed and is therefore either void or liable to be set aside accordingly. The December 1998 appointment is alleged to have been made in the belief on the part of the defendant and its directors that the ZVM Trust held assets of only $100. If, as the claimants contend, the ZVM Trust in fact held assets of substantial value, the defendant, in making any decision to appoint the assets of the ZVM Trust, did so on a false and mistaken belief as to the assets subject to any such appointment, and therefore failed to ask themselves the correct question. So we based ourselves on the sworn evidence of Khalid, the sworn account which said the assets were only $100, and the case pleaded 3 times by way of defence that the explanation for the 1998 appointment was that it was to clear up what to do with the $100. Now, what in that state of the pleadings, what you would expect Gany to do by way of evidence would be to adduce evidence to contradict our pleaded case that the 1998 appointment was made in the belief that the assets were only $100, and to prove their own recently pleaded case that the reason for the 1998 appointment was to give effect to Ma's wishes, i.e. that the ECL-HK shares should go to ASIF. And it would have been quite easy, if true, for Gany to prove both those points, which were the points asserted in the Mauve amendments made in March 2014. But they didn't in fact do either of those things. And the really important evidence on this point was that given by Mr. Salim. Mr. Salim was a close friend of Ma. He had worked in the family businesses. He had been a director of ECL-HK from 1996 until 2001. And after Ma's death, he became a director of Gany. Now, the critical evidence, this is in volume 5 at 2076. The critical evidence on which really this whole point turns is in paragraphs 14 and 15 on page 2076.
When was this one?
This was the 17th of April 2014, so it's after the Mauve amendments had been made to the pleading, alleging that the explanation for the appointment was to give effect to Ma's wish that ECLHK should be transferred to ASIF. And he says in paragraph 14, I recall a meeting that took place on the 22nd of December 1998, not long after the death of M.A. Rangoonwala. The meeting was a meeting of the directors of Gany, and it took place at Banu Rangoonwala's home called the Four Seasons. The meeting was held to discuss the appointment of any assets in the ZVM Trust to ASIF, who I understood was a beneficiary of the ZVM Trust. I was aware that there were no assets of any significance in the trust, as all businesses were already transferred to ASIF in Mr. Rangoonwala's lifetime. 15. At the meeting, the directors of Gany who were present discussed the draft resolution and board minute. ASIF Rangoonwala told us that the documents were prepared by Mansour Ahmed Khan Advocate and that they provided for the transfer of assets out of the ZVM Trust to ASIF. There were no significant assets in the ZVM Trust because, as I have explained, I always understood that M.A. Rangoonwala had transferred his businesses to ASIF. The directors who were at the meeting agreed and that we should sign the resolution. The board minute notes that I was authorised to execute the resolution appointing the assets. Now, a number of points on those two paragraphs. One, he does not dispute the respondent's case, which I read as pleaded in the reply. We pleaded that the basis on which the decision was taken was an understanding that the assets consisted only of $100. His failure to address or indeed deny our pleaded case is itself significant. Two, he does not even refer to ECLHK, and therefore his evidence simply doesn't prove Gany's own pleaded case about the purpose of the 1998 appointment. Three, he doesn't say that the basis of the decision was to give effect to Ma's wishes with regard to ECLHK, which was also part of the pleaded case. Four, he admits that there were no significant assets in the ZVM Trust, and that, we submit, is not very far from our own pleaded case that the decision was taken on the basis the assets were only $100. It's not precisely the same, but it's nearly the same. Five, he asserts that that was the basis on which the decision was taken. That about the no significant assets appears in both paragraph 14 and paragraph 15. And now, the basis on which the appointment was made was therefore admitted by Mr. Salim to have been that the appointment would transfer no assets of significance to ASIF. Therefore, we say Mr. Salim, in effect, proved our case, which was that the basis for the decision was that the assets were only $100, and didn't prove Gany's case, which was that the intention of the appointment was to transfer the ECLHK shares in accordance with Ma's wishes. In this state of the evidence, there was no need for our counsel at the trial to cross-examine Mr. Salim on these paragraphs, even if it had an opportunity to do so, which he did not, because the video link broke down and an application was then made for his evidence to be admitted under the Evidence Act. The respondents were and are content to accept that the basis on which the 1998 appointment was made was as described by Mr. Salim in those two paragraphs. And that meant that if it was proved that the assets which actually passed under the appointment were of significance, the case on misconception was proved. Now, there was an affidavit from Banu Rangoonwala, who was at the meeting, but she didn't refer to this meeting at all. That's at page 2040 of this. And the only evidence she gave about the trust assets was in paragraph 16 on page 2043, where she said, I understand that the ZVM trust is the main issue. I don't know much about the details of the trust, but my late husband told me it created the settlement as a possible place to put his wealth and make provision. That said, my husband gave Asif most of his business assets, at least those that didn't go to charity, and Asif decided to provide for his siblings by distribution of funds, which took place in the way I described below. So there was no need. Banu Rangoonwala, having not given evidence, although present at the meeting, about what took place at it, not having contradicted our pleaded case, and not having proved the Gany's pleaded case, there was no need for her to be cross-examined either.
Mr. Asif must, I suppose, have known before 2001 what was in any accounts of ECLHK, or if there were any accounts of Gany, although it appears he resigned, at least in relation to Gany, in 2001.
Yes.
Is there anything in his evidence which tells one whether he was reminded of what was in those accounts, or whether there were any accounts? I'm thinking of both Gany's and ECLHK.
I don't think from recollection, I don't believe any reference was made by him in his witness statement or in his cross-examination to Gany's accounts. His evidence about the deed of appointment was in paragraphs 103 and 104 of his witness statement, which is at page 2028. And what he says there is, under the heading deed of appointment, another matter to attend to following my father's death was the ZVM trust. The siblings had all now confirmed that no claim on the ZVM trust, and I didn't want to have the complication of ECLHK being still owned by it or having to deal with anyone in Hong Kong. When I went back to Pakistan for my usual Christmas visit, I went to see Mansour Khan. His advice was that Gany would have to pass a resolution. Then he talks about the board meeting in paragraph 104 and just says, I showed the directors the draft resolution. They reviewed the same and approved the drafts. Mr. Salim was asked to have them typed out, and he gave them to me. He was not to give these documents to anyone or show them to anyone. So he doesn't give any evidence in that paragraph to contradict or qualify in any way Mr. Salim's evidence in his witness statement, which was quite clearly that the basis on which the decision was taken was that no significant assets would pass under the appointment which was being decided. What's this? So that was the witness evidence, and what then happened was the parties exchanged skeleton arguments, and the position which we took in our skeleton was that because it had been conceded now belatedly that ECLHK was part of the trust, it followed that we made our case on misconception. That was in paragraph 48 of our skeleton, page 349 of bundle 1. In a sense, this question has been conceded. Sorry, the heading was, did the ZVM Trust ever own assets of substantial value? In a sense, this question has been conceded, since it's now common ground the ECL shares were part of the trust. And I mentioned that reference was also made in Asif's skeleton. That's begins at 373, and at paragraph 10. Sorry, first of all, paragraph 7.4, page 377. The issue is identified in subparagraph 4 as being one of the issues for the judge to decide whether the exercise was flawed because of a failure to ask the correct question. And then at paragraph 10 on page 378, ECLHK is a management company which at the time of the 1988 appointment had net assets of $3.5 million, about US 450,000 at that time. So attention was drawn in the trial to what the accounts showed, which therefore makes it all the more inexplicable that when the learned judge came to give his judgment, he simply said there was no evidence about ECLHK having assets of substantial value. I've mentioned the course of events at the trial. Some reference is made in my learned friend's written cases to the fact that we somehow needed to cross-examine on the misconception point. It's difficult to see how one can cross-examine a witness who has not been called. The application that was made when the video link went down was that the evidence of the two witnesses who were going to give evidence in that way, that's to say Banu and Mr. Salim, our application was made for that evidence to be admitted under the Evidence Act. And Mr. Cooper, who was appearing for my clients at the trial, said that he wouldn't object to that as long as he could take all the points that he would have taken had he been able to cross-examine. And having asked the trial judge to proceed in that manner, it simply doesn't lie in the mouth of my learned friends to say that we should have cross-examined on the misconception point. We didn't have that opportunity. And in any case, for the reasons I've pointed out, there was nothing to cross-examine about. Mr. Salim's evidence effectively made our case and didn't prove their case, and Banu's evidence didn't touch on the point at all. And there is a reference, actually, to the judge commenting in the closing submissions to the fact that the accounts showed approximately $4 million of assets. That's at Bundle 2, page 952, lines 1 to 3. So just, therefore, pulling the threads together, paragraph in the judgment of the learned judge, paragraph 73, page 191, and the critical sentence is in the middle of the paragraph in reference to the ECLHK shares. No evidence was adduced to show that that would have amounted to anything substantial in December 1998. And then there's a reference to Asif's evidence. And that was incorrect. And it was incorrect simply by looking at the accounts. The point that was taken about there not being a formal valuation doesn't get my learned friends anywhere. The accounts were audited accounts. They were signed by the directors. They were said to show a true and fair view of the company's affairs. And that it showed substantial assets. Reference is made to one of the assets being an intercompany debt. So be it, but if the accounts are showing a true and fair view, it's on the basis that that debt is a recoverable debt. So there's nothing in any of that. But he does say in paragraph 73, seems to me the factual matrix against the decision was taken was that the trust had ceased to have any significant assets or any significant purpose. And that is true, but it doesn't undermine the point that the directors were quite clearly labouring under a misconception in that regard. Now, on the question of whether it's a breach of trust.
Thank you. Yes. Yes, Mr. Paul.
I think I've already made the point that the basis of the decision was that they weren't really exercising the power of appointment in any significant dispositive way, and that's the thing that really undermines the decision and demonstrates that it was indeed a breach of trust. I don't think I need to take your lordships through Pitt and Holt, which is a clear exposition of the law. I say perhaps just to mention paragraphs 91 and 92.
Which flag?
I'm so sorry, I've just lost it for a moment. Volume 2. Volume. Oh, thank you. It's volume 2, tab 29.
Sorry, page.
(4134).
Yes, page 4134.
Mm-hmm.
This is the would or might point. And I won't read this out. But there's a reference made in paragraph 92 to Stannard. And that's talking about family trust, whether it's appropriate for pensions trust, since members of a pension scheme are not volunteers but have contractual rights. In practice, the court may sometimes think it right to proceed in that way, but as a matter of principle, there must be a high degree of flexibility in the range of the court's possible responses. Relief can be granted on terms. The court may wish to know what further disposition the trustees would be minded to make if relief is granted. To lay down a rigid rule of either would not or might not would inhibit the court in seeking the best practical solution in a variety of different factual situations. And that, we say, leaves the door wide open to the course taken by the Court of Appeal here, once you understand what was the defect in the reasoning of the directors. It's obvious that the decision cannot stand and is a breach of trust. And that there was something more to do with the trust than simply clear up a trust which had no significant asset. Now, can I just deal briefly with one other point that was taken about the Court of Appeal's judgment? We submit this was unfair criticism of the judgment. This is the point which arose on paragraph 76 at page 246. It's the second sentence that was criticised, and it said that's wrong because the judge obviously was proceeding to try the case on the basis that the ZVM Trust didn't merely hold $100 but also held the shares in ECLHK. That was the point that was taken. The problem with the submission is that the correct position was identified by the Court of Appeal in paragraph 99, at page 254, where they said there is no evidence of Gany's thought processes at the meeting. However, the likelihood is that it was of the same view as Mohammed Salim. Well, we now know what that view was because I've shown it to you. And then this, the learned trial judge opined there was nothing in the trust apart from the ECL HK shares and indirectly whatever assets ECL HK may have held beneficially. Now that shows you that the Court of Appeal was fully aware of the point that the judge was proceeding to hear a case on the basis that Gany didn't just own $100 but also owned the ECL HK shares. And that was the basis on which, this is the paragraph which actually contains the Court of Appeal's reasoning on this point. So just looking at, as we've got it open, the paragraph 96, leaving aside the other significant companies presumed by law to form assets, the judge felt there was no evidence of any significant assets. This was the basis on which he felt there was no misconception. The evidence points to the fact that the trustee was presented with information which indicated that he was winding up the trust and giving very negligible asset to Asif. Well, that's obviously Mr. Salim's evidence. There was no evidence to indicate the trustee acquainted itself with the relevant matters, chief of which was the nature of the assets that formed part of the ZVM trust. And that's absolutely clear once we understand that Mr. Salim, in explaining what happened, made no reference to ECLHK, which was the asset of the trust. So I think that's probably all I have time to say on the second ground. May I go on briefly to the liability to account? This is a short point. If you would look at page 261, paragraph 5, it's volume 1, page 261. The order made by the Court of Appeal was that Asif Rangoonwala should account, this is paragraph 5, for all of the assets received by him as a result of the 1998 appointment. And that is based on paragraph 110 of the judgment, which is at page 257, paragraph 110. After dealing with the knowing receipt case and rejecting it, the Court of Appeal said, even though there was no basis on which the judge could have held that Asif was personally liable, this doesn't bring the matter to an end. Asif must be required to return the ZVM trust assets that he has in his possession, which were improperly transferred to him by Gany. It cannot be sufficient for him simply to assert that he's parted with the assets. If, however, he asserts that the assets are now in the hands of a third party, the trustee should be able to trace them with a view to determining the veracity of this contention. So this question concerns the position of the recipient of assets pursuant to an exercise of a discretionary power which is subsequently set aside. The recipient now has the assets which do not belong to him, but to the beneficiaries of the trust from which he received them. Does the law leave the beneficiaries of the discretionary trust without any remedy in that situation? We submit self-evidently not. We submit that the recipient must return all of the property which he received to the trustee, or, if he has parted with the property, he must tell the beneficiaries what he's done with it.
On the footing is this, that if your submissions are correct on the two principal points, he's a knowing recipient?
Well, he's not legally liable as a constructive trustee for knowing receipt of trust assets paid in breach of trust. That has been determined against us.
He's a voluntary recipient.
He's a
But he's liable for that of which he has not disposed.
Exactly.
He's a voluntary recipient who's received it gratuitously.
Yes.
Yes.
So the simple proprietary remedy.
He's given no
Yes,
consideration.
which has two forms. One, to the extent he's still got the assets, he should say what he's got and return them. And if he's parted with them, he should say what he's done with them. And we can't understand why he wouldn't do that. Why is he appealing this point? Why won't he just give an account, as the Court of Appeal has ordered? I mean, the question for your lordships is there a basis in law for the conclusion arrived at in paragraph 110? And we submit it's absolutely obvious that there is, and that we are entitled to the account, and that it's not an answer to that point to say, oh, well, he's already explained what happened. That won't do. He should account formally. He should swear an affidavit and give an account of what assets he's got, and if he's parted with them, what he's done with them. So that deals with that point. And that, I think, if authority were needed for that, it is in fact in a first instance bit of Pitt and Holt. The other case in Pitt and Holt was called Futter and Futter, and Mr. Justice Norris dealt with this particular issue in the last paragraph of his judgment in that case, which is in the Authorities Bundle 1, tab 16, paragraph 35, page 3787. He said, any property passing as a result of their execution has been held by the recipient upon constructive trust for the trustees of the number 3 and number 5 settlements, and it or the property now representing it must be returned to the trustees and an account given of all income received. Now, of course, the appeal in Pitt and Holt held that he was incorrect in the main reasoning, but that doesn't alter the fact that he was correct on that point. So I think that's all I need to say about issue 3. And issue 4 is also a very important point. Can I refer you to page 265? What happened here, as you see, this is a corrected certificate of result of appeal, and it's referring to applications held on the 20th of July 2016. And just before I hereby certify, it says the court also heard and determined a dispute between Mr. Rangoonwala and the respondents as to the proper construction and effect of the March 2016 order. And the result of that dispute was that the Court of Appeal determined at paragraph 5 on page 265, the effect of the March 2016 order is that the entirety of the order made at first instance by Mr. Justice Bannister is set aside. And it's that determination on the construction issue which is appealed by my learned friend, Ms. Proviso. Now, what happened, we say the decision of the 20th of July was obviously right, and that the appeal should be dismissed. What happened was that after the trial, Asif, because the claims were all dismissed, Asif got an order for his costs of the trial from Mr. Justice Bannister. But we appealed against the whole of that order, including the costs order made in Asif's favour. And that's clear from examining the notice of appeal at page 197. What the notice of appeal says is that we appeal from the judgment and the costs judgment. And over the page, at page 198, an order's not yet been entered, but the appellant's appeal against the learned judge's conclusion that their claim fails and its consequent dismissal, and the order that the claimant pay the first respondent's costs from the 21st of February and the second defendant's costs in full. So there's no doubt what we were appealing. We were appealing not just the substantive order, but also the costs order made in Asif's favour. And then at page 205, the order originally made by the Court of Appeal, I'm so sorry, page 205 is part of the Notice of Appeal, where we sought an order that the appeal be allowed. And then we go to the page 260. The certificate which was being construed by the Court of Appeal in July 2014 was this certificate, and at page 260 what it says is that the appeal is allowed. What was the appeal? It was the appeal set out in the Notice of Appeal, which was an appeal against all of the orders made, including paragraph 3 of Mr. Justice Bannister's order of the 13th of June, which was the paragraph which gave Asif an order for his costs. So we submit that as a matter of construction of the original certificate of appeal, it's quite clear that by allowing the appeal, the appeal referred to included our appeal against the costs order in Asif's favour, and that when the Court of Appeal was asked to rule on that point in July 2014, it correctly determined that that was the right construction of the original orders.
So what was the upshot that no order for costs was made in relation to the trial?
No, we got our costs of the trial from Gany.
That's paragraph 6.
Yes.
Yeah.
Yes,
of course.
We're not here talking about our recovery of costs. We're talking about the order for costs which Asif got from the trial judge, and that was set aside by the Court of Appeal.
The question of construction was whether paragraph 6 covered the ground on costs, and therefore, by saying nothing about it, left your cost liability to Asif intact.
Yeah.
And the Court of Appeal, on a second view, said, albeit a differently constituted court, so it's not the right way of looking at it.
Not the right interpretation. But the words the appeal allowed meant the appeal was before the court, which included an appeal against the costs order in Asif's favour. I managed to stop 1 minute over time, I think, according to my watch anyway.
Thank you. Mr. Wilson, do you follow?
My Lords, if I may just touch on one point that my learned friend Ms. Supervisa made. It was this, in relation to the arguments put below in the Court of Appeal. Your Lordships will note that there is criticism of the Court of Appeal's reference to the 1998 appointment being void. We've set out in our written case why we say, in fact, they found it was voidable and set it aside, because there would be nothing to set aside were it void as opposed to voidable.
Yeah.
But it was said by my learned friend that my skeleton argument at page 420 of Bundle 1 put the case on the basis that it was void. That, in my submission, is a misreading of it. If one looks at it, and I'm not going to take your Lordships to it now in view of the hour, but there were two alternative arguments run in the Court of Appeal. One was the argument that your Lordships have heard based on Pitt and Holt, which leads to a conclusion that the appointment is voidable. The other argument that was run was based on a case called Turner and Turner, which is where trustees simply don't apply their minds at all to the question of whether they are exercising a discretion. If one is successful in that challenge, the result is that it is void and not voidable because the trustees have never exercised their discretion. That point was run. That is why the references to void are in the skeleton, as one can see from the skeleton. We were unsuccessful in the Court of Appeal, and no cross-appeal has been brought on that point.
Thank you very much. Mr. Crowe.
Lord, very briefly, that point you've just heard may well be another illustration of the clear water that develops between an oral hearing and 14 months later, a reserved judgment. The Court of Appeal clearly said void twice. It did not say voidable, and it did not go on to consider the exercise of its equitable jurisdiction. I have a string of very short, but I think significant points, if I could just run through them rapidly. The first is just to correct a cross-reference I gave you. I said that the first instance judgment referred to the accounts of ECL Hong Kong twice, once at paragraph 13, which is correct. The second reference I gave you was wrong. I said paragraph 73 for some reason. It's actually 26. So ECL HK accounts referred to at 13 and 26. I just wanted to respond briefly. My learned friend's chronology in his opening 20 minutes or so was directed as much as anything towards a sort of opening submissions at a trial. And they demonstrate in our submission the dangers inherent in trying to get an appellate court in the course of a one-day hearing to get any sort of handle on the facts of a case which was heard over a trial of 5 days. Can I just give one illustration of that? My learned friend tried to make some capital out of the fact that in 2010-2011 there was a proposed reconstruction or rearrangement of the trust, and he sought to draw an inference that that must have meant that there were valuable trust assets. Can I just point you at one document, one entry on the chronology to show the kind of counter-narrative that was available to the trial judge. It's page 3291, and it's just over halfway down the page. It's the entry for the 29th of August 2010, right in the middle of all this process. And it's, in one sense, a rather boring document from, with respect to them, relatively lowly operatives. It's from a PA to Harney's. And what she is saying is inquiring about converting Gany into a private trust company. She says the trust and the trust deed exist for some years, but there were no assets in the trust. It has now been decided to regularise all the administrative issues before any assets are transferred into the trust. Now, that is the kind of document that was in front of the trial judge, which gave a completely legitimate basis for him to reject the suggestion that there were valuable assets in 2010-2011.
Does he refer to this document?
I think he does, but we will find that in a moment. But the other point, which I know he does refer to, and which I can give you the reference to, is this, that in paragraph 51 of the judgment at first instance, the trial judge refers to the long list of companies which are referred to in a memorandum to Taylor Wessing, who were being instructed in relation to this proposed reorganisation. But he points out that of the 23 companies that are listed, only 8 of them had actually even been incorporated during MAR's lifetime. So the suggestion that simply because company names are put on a memorandum addressed to Taylor Wessing implies that the email is referred to in paragraph 52. It's the very next paragraph in the judgment. Those are, in our submission, the sort of evidential points that come up at trial whose significance is evident to the trial judge, and it is just a tiny illustration of why it is entirely wrong to invite appeal courts to trespass into the fact-finding exercise, which, with respect, this kind of tribunal, and the court below in particular, is not an appropriate place for that to be done. Ground one, my learned friend didn't, in fact, defend the Court of Appeal's judgment. The Court of Appeal's judgment, as I hope we demonstrated in opening, is avowedly based on a legal principle which raises a presumption and reverses the burden of proof. Nothing, my learned friend said, sought to uphold that. He says, well, we can jog along just as well with these facts raising an inference. Now, one may or may not agree with that as a general proposition of what one gets from Ree Curtis. But if that is what he accepts Ree Curtis to mean, that all it is an illustration of a case in which an inference of fact was drawn then the appeal to the Court of Appeal was put forward on a false basis, and the Court of Appeal decided it on a wrong view of the law. So my learned friend is not seeking to uphold the ruling of the Court of Appeal. The Court of Appeal overturned Mr. Justice Bannister because it said in terms he made an error of law, paragraph 85, and because the three companies were presumed by law, paragraph 96, to be trust assets. And my learned friend has not sought to defend those findings, and for that reason, in our submission, there is no answer on ground one. If the trial judge made no error of law, the Court of Appeal can only interfere if his judgment is perverse or entirely unsupported by the evidence. Now, my learned friend sought to go through the evidence, pointing out the kind of things that he might wish to rely on in front of a first instance judge to raise an inference that these three companies were transferred to Gany to be held as part of the trust. But absolutely none of the inferences he sought to draw about the timings of the assumed transfers and so on constitute the kind of material evidence that would be needed to satisfy an appeal court that the first instance judge has actually got it wrong. The judge was right in saying there is no evidence that these three companies were transferred to Gany when it was the trustee. Yes, there is circumstantial material that is capable of raising an inference that that is what happened, but that's not good enough in a court of appeal to overturn a finding of fact. All of those points about, well, yes, these shares in ECL BVI were allotted just a few days after this happened. Yes, fine. That's stuff that can be put in front of the fact finder at trial to raise an inference, but it is not the kind of point upon which a court of appeal can then say, well, in that case, the only possible factual conclusion is that these companies were transferred to be held as assets of in the trust. And learned friend is quite wrong on the question of timing. There is no evidence that the Schweizer Holdings or Sedilla BVI were transferred during 1994, which is what he said. The witness evidence was that the discussions between Asif and his father began in 1993, before Gany became the trustee. That's paragraph 57 of of Asif's witness statement. And my learned friend also sought to derive in our submission far more from that paragraph than he's entitled, because that paragraph is talking, if you go back to it, I don't ask you to, paragraph 57 of Asif, it's talking about the UK and the Hong Kong companies. It's exactly what it says. It is not talking about the BVI companies with which we are concerned. So my learned friend cannot make the kind of proposition he did on the basis of paragraph 57. Final point, just in relation to issue 1, he says it would be unfair to be defeated on the basis of a burden of proof, bearing in mind all the information was in the trustee's hand. Disclosure orders were made against the trustee. Third-party disclosure orders were made against Taylor Wessing, and their files were opened up. Norwich Pharmacal orders were made against Harneys, who were the corporate service providers in relation to the BVI companies. The fact that there isn't documentary material to support the supposed transfers is a reflection, which the judge duly held, of the fact that there is, in fact, no evidence. And the last point I just wanted to make is that the very fact that there is that one document signed by MAR, that's Bundle 8, page 2881, the one document in relation to the ECL HK shares where MAR specifically directs that that company be held on trust, can be seen by contrast with the absence of any comparable documents in relation to Sedilla BVI, Schweizer Holdings, and ECL BVI, to demonstrate that those three companies were not intended by him to be held on trust. Very briefly on ground 2, my learned friend seems to put in front of you the proposition that if he pleads there has been a misconception without adducing any evidence to prove it, somehow he has discharged the burden of proof. And in our submission, that is not the right approach. So far as Azif is concerned, his evidence was that he knew the ECL HK shares were part of the trust assets. If the claimant's case was that the other directors didn't know, then it was inherent in their case that Azif either positively misled them or knowingly omitted to tell them something relevant. And he was not cross-examined on that at all. If they wanted to run the case, knowing that Azif was not under a misconception as they concede, but to allege that the other two directors were, they had to cross-examine Azif and put to him that he must have misled them in order to get to that outcome. So far as Mr. Salim is concerned...
Do you have to cross-examine someone to support an allegation that you haven't made simply because it is an inference that might be drawn from an allegation that you have made?
Lord, if one is going in front of a court of appeal and saying that the judge reached the wrong conclusion in relation to a point on which the witness was not cross-examined, that is a point that I'm entitled to make in response. So far as Mr. Salim's evidence is concerned, he said that the decision was taken as far as he was concerned on the basis that there were no assets of significance. And I've addressed you that that is a judgmental matter. It is not a matter of the Court of Appeal differing on a sort of question of factual valuation, which is how my learned friend put it. It is a matter of judgment as to whether or not, in this particular context, the asset in question should be regarded as significant. And the only additional point I'd make in response to my Lord Hodges' question when I was being asked before the short adjournment about, well, what's the right comparator? In a sense, I gave you part of the answer. Well, it's the context of a family wealth in which we know earlier that year $8 million had been distributed, or agreed to be distributed. The other part of the answer is that $360,000 figure is not a valuation. It is simply what appears from the accounts. Nobody actually values the company at that amount. And as we submit, as we put in our printed case, the principal asset that's reflected in the balance sheet is a loan owed, a debt owed by a fellow subsidiary, and there's no evidence about how recoverable that actually is. My Lords, I think, yes, my learned friend addressed you very briefly, and there were the two questions at the tail end of Pitt and Holt. If a court is coming to exercise its equitable jurisdiction, there isn't a single test to be applied. The court has an equitable jurisdiction to decide whether or not to set aside a decision taken by trustees which is taken in breach of trust. There would be at least two questions that a court, maybe not this one, would need to answer. The first is whether the respondents, having established that there was a breach of trust, would then have to prove that the trustees would have acted differently or merely might have acted differently. And the second question that would need to be answered is whether, in answering that question, the test is subjective, namely, would this trustee or might this trustee have acted differently, or is it an objective question, namely, would a hypothetical, reasonable trustee have acted differently, would or might have acted differently? And those are questions which don't need to be decided because the Court of Appeal simply didn't apply its mind to it. They are matters really between Azif and the other beneficiaries rather than one for the trustee to argue. So the final point, slightly out of sequence, I should have said in relation to Mr. Salim's evidence on ground 2, we point out in our printed case, para 4312, that he was also a director of ECL Hong Kong, and he signed the accounts, so he must have known what the accounts showed. Lord, the other thing I should just say on behalf of all of us...
Was he a director in 2009?
Yes, he was a director from 1996, I think he was appointed, but I'll be corrected if I'm wrong. Just in relation, the rules require us to say before the close of oral arguments that in relation to issues of costs, if we wish to defer argument, we should tell you, and we're agreed that we should defer arguments on costs and deal with it in writing only, and we'll hope to agree any directions that would be needed in that regard. Unless there are any other points, those are our replies.
Thank you. Well, we're very grateful to Council for a clear and economic presentation of a complex appeal, and we're grateful to all those who've been involved in preparing this appeal. The Board will take time to consider what advice they will humbly tender to Her Majesty.